do education law, and then, like Rich said, we're going to move on to child welfare for the last 30 minutes. So as we go through these, if you have questions, just bring them up as we go. If we get behind, I might kind of say, write that down and ask me later, because we only have maybe like 45 minutes now. Okay, go ahead. So what we're going to talk about in the education law training are kind of, I'm going to hit the main two areas of law that we practice in education, which is special education and school discipline. And then at the end, I'm going to briefly hit on some other relevant areas that we do less cases in, including school records, Title IX cases, and residency issues. You can. Okay, so you guys should all know this. Here's LAF practice groups. Out of the Children and Families practice group, the education law team basically consists of kind of 3 different areas. Probably about 85% of our work is the Dcfs Education Project, where we represent students who are wards of the state in their education issues. So we basically represent kids who are in foster care or who live in group homes, which are also called residential treatment centers. Okay? Another big part of our project is the Pro Bono Project. So basically anyone who just calls through CSU goes to our Pro Bono Project, which is we have a panel of attorneys from outside LAF who are interested in doing education law cases, and Callie, who's sitting in the back, this is going to be really boring for her for a while, runs that project. They come in and take those cases. So we really don't have any in-house attorneys other than Callie, who's a VISTA attorney, taking non-ward cases. So that's kind of tells you a lot about the types of cases we're doing. And then we have Jamie Schulte, who's a Skadden Fellow, and she has a specific project working on CPS's option schools, which is what they call their alternative schools. So she tends to work with older students who are in Chicago. And these are all the areas that we kind of do cases in. Okay, so I like to give this slide, even though you guys are not here to talk about youth and care, which is the name that we call wards. I like to put this up here because I think it's an important PSA as to why, other than the fact that we have a contract to do this work, why it's so important. Because I think you can see universally, children who are wards of the state have worse education outcomes in almost every single category you can think of. And there's some pretty obvious reasons for this, but I think it's just kind of drives home how important it is to make sure these kids are getting as much help as they can in whatever their education issues are. Okay. Okay, so first we're going to talk about what is the main special education law. When we talk about special education, the main law that we're talking about is the IDEA, which is a federal law, of course. It applies to students with disabilities from birth to 21 who need specially designed instruction in order to benefit from public education. The Illinois School Code has sections that build on top of the IDEA. They put in more specific requirements. They put in some more specific timelines, but it's all just part of the implementing regulations of the IDEA. Everything is based in the IDEA. Okay. So, how many of you have ever heard of an IEP? Like, even heard that word? Yeah. I mean, I think most people, especially if you went to public school in the United States, probably have heard of an IEP. Probably you might have had one, or a friend might have had one. Basically, it stands for an Individualized Educational Program. It is a written legal document. It can be anywhere from 5 to 40 pages that details what that services that student is going to receive in school for 1 year. And they're redone every year, sometimes more frequently than that. But they're only for students who have disabilities that impact them in school. And we're going to get to that later and why that's important. It's not just for all students with disabilities. It's just for those with disabilities that adversely impact their progress in school. And it has to outline certain things, including goals, accommodations, modifications, related services. All has to be in that document. And it describes what that student is getting in school. Okay. I'm going to talk about this briefly because we're going to come back to this a little bit later. But you might have also heard of a 504 plan. You probably also have heard of the Rehab Act and are aware of section of 504. 504 and IEP. Some people tend to describe a 504 plan like an IEP light or like a pre-IEP, but that is not correct. That is not how you think of it. A 504 is for a student who has disabilities who maybe just needs some accommodations in school, but does not need special instruction or special services. So technically, if you were looking at this like a little diagram here, students who are IEP eligible could technically also have a 504 plan. Nobody really does that because the IEP is more inclusive and more detailed, but some students who are 504s probably should have IEPs instead. And I'll go into that a little bit more later, but I just wanted to put that out there before we go any further, because sometimes people get the two confused. Okay. Okay, so a lot of our cases kind of come in one of two postures. Either the student we think needs an IEP, or their parent or their caseworker who referred them thinks they need an IEP, or they have an IEP, but they think the services need to be changed. So, starting with the first scenario, when we think a student may need an IEP, generally what we tell parents or caseworkers or anyone else who refers a case to us, that these are certain things that might indicate that a student needs an IEP. One, just one of them is poor grades and low standardized test scores. That's not the only thing, and it's not required, and it's not sufficient. It also could be because they're missing milestones. This would be especially true for the younger kids. You can have an IEP starting at 3. So that's usually when you see the little kids, right? They don't know how to read yet, obviously, so you can't test their reading level. But you can see they're missing other developmental milestones. They have a hard time concentrating or paying attention in class. They have multiple or frequent behavioral issues. This is a big one. For our cases, a lot of our clients have trauma and neglect histories, which can frequently lead to behavioral problems in school. They have a diagnosis. Diagnosis doesn't mean you get an IEP, and not having a diagnosis doesn't mean you don't get an IEP. Okay? It's helpful, but you don't need it. But if a student does have a diagnosis, it probably means, meaning from like an outside doctor, that probably they should have an IEP, and it's a discussion that we should have. Or the student has significant medical needs. So a lot of our students fall into kind of a emotional behavioral disabilities category. Some fall into kind of more of a learning disabilities category. And then some of our students are medically complex, so they maybe have many overlapping medical concerns that basically severely impair them in school. Okay, this is our first true or false. This is what the little paddles are for. We're testing knowledge already. So true or false, and if you think it's true, then you show me the green. If you think it's false, show me the red. A student needs an outside diagnosis from a doctor in order to get an IEP. False, that's right. You don't need an outside diagnosis. We tell everyone it would be helpful if you had one, but you don't need one. It's not required to get in the door for an IEP to have a diagnosis from a doctor. Okay. Second, a student who's passing all of her classes doesn't qualify for an IEP, true or false? Right, also false. A student could be getting all A's and still qualify for an IEP. And that's because IEPs are not just about whether you're making academic progress, it also looks at whether you're making social emotional progress in school. If a student, for whatever reason, is acing every class, but is constantly getting into fights with their peers, has no good relationships with teachers, is getting suspended all the time from school, but yet they still manage to get A's, that student may still qualify for an IEP. So it's not just about academics, it's about how the whole student is functioning in the school. Okay, the basic process for IEP eligibility. So this is the process that basically a student would go through at the beginning of trying to get an IEP for the first time. So somebody, usually a parent, or sometimes it's us in our cases, requests a case study evaluation. If the school agrees to the case study evaluation, then we have what's called a domain meeting, where you sit down with a bunch of people at the school, and usually it's a psychologist from the school, and depending on what the student's needs are, there might be a speech-language pathologist there might be an occupational therapist there might be a physical therapist there might be a social worker, there might be a nurse, there should be a special education teacher, a general education teacher, the parent, us, the student, if they're 14 or over, a whole bunch of people. And they sit down and they say, what areas do we need to evaluate this child in? And normally those are things like, do they need a speech-language assessment? Do they need an academic assessment? Do they need a cognitive assessment, right? That's an intellectual IQ test. Versus academic looks at what is your actual achievement in school. Do they need a sensory profile? That's something an OT would do. So you discuss as a team, and you're supposed to make a decision as a team about what does this student need. They write it all down, and the parent signs consent. And then the evaluation process starts. So then they do the evaluations. We didn't put all these timelines up here because it's not important for you to know all these little details, but this takes a long time. They have 60 school days to do this. That's 60 school days. So like if I'm signing a consent tomorrow, I'm looking at like December or January before we have the eligibility meeting. So it's a slow process. Then you have the eligibility meeting. All those same people come back to the table. They discuss what their evaluations show, and then decide whether the student is eligible. If the student is eligible, then the team writes an IEP while you're at that meeting. Ideally at the same meeting. Sometimes you have to come back. But that's the basic process. Once this process is done, a student has an IEP, and they have it forever until they graduate from high school or they turn 22 years old. Some students are never really going to graduate from high school, those with very serious disabilities. And so eventually they just age out. Okay, and then the next one. Okay, true or false? Only a parent can request that the school complete a case study evaluation. I don't think I realized that all these are false so far. You're right, that's false. Anyone can request it. Most of the time it is the parent. In our cases, a lot of time it's the Dcfs caseworker, but it could be a teacher. And we have seen it where a teacher will request that the school do a case study evaluation for the student. But most of the time it's the parent, but anybody can do it. Okay, so we talked about the eligibility meeting and all those steps, but how do you actually decide if they're eligible for an IEP? So basically, the student has to meet the criteria for one of 13 eligibility categories that are defined in the federal regulations. And that disability has to be negatively impacting their educational performance. Again, note this word, educational, not academic. Educational is lots of stuff. It's not just your grades. And because of that disability, they need special services and instruction. A student can be eligible under more than one category. For example, you could have a client who has a cognitive impairment, which is one way of saying intellectual disability, or a long time ago what they used to refer to as mental retardation. And they could also have an emotional disturbance, which is another term that they use that's kind of the catch-all category for students with emotional behavioral disabilities. It's kind of a, people don't like that term disturbance, but that's the technical term in the regulations. So you can have a student that has both. We have lots of students that have an emotional disability and a specific learning disability. We have students who have other health impairment, which is a kind of a catch-all category, which a lot of times means kids who have ADHD, but it can mean other health impairments. And they also have an emotional disability, or they have a speech-language impairment, and they also have a specific learning disability. So it's not uncommon to see this. And with our kind of medically complex kids, you can sometimes have too many to put on the IEP. And if you go to the next slide, these are all the categories. So these are all defined where that site is at the bottom. The most common ones that we would see are other health impairment, which can include any kind of a health issue that impacts your attention and your ability to kind of sustain throughout the day. Like we've had clients where we've argued that this applies because they have sickle cell, so they can't really keep active in class for a full school day. We see a lot of specific learning disabilities. Sometimes people don't understand the difference between cognitive impairment and learning disability. You can have someone who is very intelligent, average intelligence, medium, low average intelligence, and have a learning disability. And that means that one type of learning is harder for them than the other types of learning. So normally you'll see a student, for example, who has a learning disability in reading. One example of that would be dyslexia. But they're not all named the way that dyslexia is, and you don't have to call it dyslexia. But that's an example. But a kid with a learning disability is not low IQ. They're usually average or low average or above average. But for whatever reason, they have a harder time processing a certain type of information. So they need to be taught in a different way. We have clients who have autism as its own category, Cognitive impairment is its own disability. Speech language impairment, very common, especially for littler kids. Sometimes they grow out of that. And we have a lot of clients who are emotional disturbance, which is kind of the catch-all for kids with emotional behavioral disabilities. So these are all defined, and basically at the eligibility meeting, you go through the definition and say, do they meet the criteria? Check, check, check. Okay, they met the criteria. Is it adversely impacting them in school? And that's how you decide whether they get an IEP. Okay. So an eligibility category is not a diagnosis, and we sometimes tell parents this, and this is why sometimes we say to parents, it might be useful for you to go and try and find an outside psychologist to do an assessment to see if you have a diagnosis first, because I think some parents come to the school thinking that they're going to diagnose, and that's not what they do. They don't diagnose. It's just whether you meet the criteria for that category as defined in special ed law. It has nothing to do with like a DSM-5 diagnosis. At the same time, we have seen clients, for example, who have a diagnosis of autism from a doctor, and the school refuses to say that they meet the eligibility category for autism. So you sometimes have this back and forth where you have a diagnosis, the school won't acknowledge it, or where you don't have a diagnosis and you want one, but the school's like, we don't do that. Okay, the category does not determine services. The student's individual needs determine services. So just because you have a student who has an emotional disability, that doesn't mean that the only services they get in school are going to be social emotional. If they're also struggling in math, then they should get special education minutes in math too. So the category does not limit services. And someone once explained this at a training I went to a while ago, and I thought it was the best analogy. If you think of an IEP as like the room, the category is just the door that lets you into the room. Once you're in, you're in. And then everything is open for discussion. So if you have a student who has a specific learning disability category, they can get social work services. They don't have to have emotional disability as their eligibility category to get social work. Same thing, if a student has an emotional disability category on their IEP, but they need extra help in reading class, they can get minutes in their reading class, even if they didn't meet the criteria for a learning disability in reading. So the category is just what gets you in. Once you're in, you talk about what does that student need, and that's what drives the IEP. And this is what we talked about before. This includes social, health, emotional, communication, physical, and vocational needs, right? It's not just about what the student needs in a classroom academically. If the student, for example, has severely impaired functioning in one of their hands, maybe they had a traumatic brain injury, maybe they have cerebral palsy, they can get occupational therapy to work on their fine motor skills because they need to be able to use their hands to write in class. If they need to be able to run, jump, and climb stairs in the school, they would qualify for physical therapy. If they need to be able to communicate, which everyone does, then they qualify for speech language services. So it's not just English language arts, math, social science, and those things, right? It's all of these things. Okay, true or false? Every student who has a diagnosed disability should have an IEP. That is false. So there are students who have a disability who do not qualify for an IEP, and that is correct. There are some students who have a disability and they should have an IEP, but the school said no. But for example, you could have a student who has diabetes. Technically that's a disability, but do they need specialized instruction? Probably not. Do they need a smaller classroom or a teacher who helps them learn specifically how to decode vocabulary words? Do they need social work? Probably not. There might be exceptions. Do they need maybe just an accommodation of being allowed to go check their blood sugar once a day? Yes. Then they get a 504 plan. But they don't need specialized instruction or specialized services. They just need an accommodation. For example, you have a student who uses a wheelchair. No other disabilities, just uses a wheelchair, okay? Do they need an IEP? No. They need a school that's accessible and has ramps and or elevators inside, which they could all get through a 504 plan. So that's kind of where the difference goes. Okay, a student can be eligible for both speech language impairment and specific learning disability. Kind of, you had a true one. True. You can have 2, 3, sometimes they cut you off at 4 categories. But you can have as many eligibility categories as apply. Okay, what is actually in the IEP document? Like I said, it could be anywhere from like 5 to 40 pages, sometimes longer than that. What is generally included is what is the eligibility category, what is their present level of performance.
Sorry, quick question with regards to that second question.
Yeah.
What's the benefit of labeling them with more squares?
Yeah.
If it only gets them in the room in the first
Yeah.
place?
We like to make sure that as many categories as apply are on the IEP because it does, even though it should not legally, technically drive services, sometimes it does. And we have found, for example, that if we have a student who we go to an eligibility and the speech language pathologist says, well, they have some impairments in their receptive communication, and I'm going to give them a goal, and I'm going to work with them for 15 minutes per week, so they're getting speech language services. But they say, but I don't want to find them eligible under that category. You know, they already have the SLD category for learning disabilities, so I'm not going to put that. Sometimes we will push to add that as a category because 2, 3 years from now, all of a sudden they've forgotten about the speech language problems. And sometimes when you look at the eligibility categories on the first page, you want it to be as descriptive as possible. A big problem we see, for example, is students who clearly have an emotional behavioral disability, and that's what dominates, right? They're super disruptive in class, they're getting in trouble all the time, and that is what everybody is noticing. But then in the course of the evaluation, somebody also realizes they also have a learning disability, which we can't even get into all the overlap that's going on there probably. But in that case, we would really push to put both of those on the IEP because I don't want them to forget a year from now that not only does this child have an emotional disability, but they also have a reading learning disability. And you can't just pretend like it's all about behavior. So sometimes even though technically it shouldn't drive services, we want someone to pick up the first page of the IEP where it says the eligibility and get as clear a picture as they can. Okay, so eligibility category always on the first page, present levels of performance. That means that every year they're supposed to put in there a clear measurement of how the child is performing in all these areas. Accommodations and modifications. This is the section, right, where some of these, when we talk about 504s, we talk about accommodations and modifications. Obviously, you can also get them in a 504. So what would this be? It could include extended time on tests, taking tests in a separate room, having a teacher come by and check on you every 5 minutes. Maybe it includes having extra time to determine your homework. Maybe it involves limiting for certain students who have vision or processing issues. We limit the number of test items on a piece of paper so that they can process it better. Maybe it's letting them take certain exams instead of on the computer. They can take the paper pencil version because it's easier for them to follow along. It can be really hard for kids to do the answer sheet, test booklet, answer sheet, test booklet. So they might have an accommodation where it's all on one document. An accommodation modification could include it's basically infinite on things that you could include, but those are kind of the ones that you most likely think of. Another thing that would fall under that would be an aide. Sometimes we have students who have a shared aide, so not a teacher, but like an additional adult in the classroom who is kind of helping the teacher, but through their IEP, that person has to be there. We have certain limited circumstances where our client has a dedicated aide, which doesn't mean they're just good at their job. It means they're dedicated to that one student, so they're a one-on-one aide. That would be for a student who has some pretty serious needs. Every IEP is going to have goals and benchmarks. So it has to have measurable goals that the student is supposed to achieve every year. And that becomes really important later because if they don't achieve those goals, then that's when everybody sits down at the annual review and says, what do we need to change here? Related services? Oh, wait. Can you go back? I'll tell you what was on there. Oh, you did? Okay. So related services. This would be stuff that's not instruction. So social work, speech language services, occupational therapy, physical therapy, nursing minutes, transportation. Some kids get transportation because of their disability. All those things would be related service minutes. And program placement. This is where we talk about what type of classroom, what type of school is the student in. So we have things called special education classrooms, which means that all the students in the room have an IEP, and they by law are smaller class size. And there's a special education teacher teaching. You also have situations where the special education teacher pulls you out to work with you separately for a couple minutes. We also have situations where the special education teacher pushes in. So there's 2 teachers in the classroom. We also have students when they have kind of a more serious, very extreme disability where they go to what is called a Therapeutic Day School or a separate day school. That means they are at a separate school that everyone has an IEP. And they're usually smaller and much more specialized. But there's a whole spectrum, basically, of placements that a student can have within their IEP. And an IEP, overall, is supposed to be reasonably calculated to provide the opportunity for the child to receive meaningful educational benefit. There was just a Supreme Court case that came out and said, "Hell, what's meaningful?" And this is the question for all of our cases. What is meaningful? And thankfully, the Supreme Court, the school districts were trying to push them to say that de minimis progress would be meaningful benefit. Like if they moved up this much in their reading, if they made any progress, that they were doing what they were supposed to be doing. Thankfully, the Supreme Court said no. You need to look at what the student's capable of and decide what's appropriate for them based on their disability, but de minimis is not enough. So that was a good decision for us this year, at least in that it didn't make things worse. Yeah.
Is there any overarching concept of a preference for mainstreaming or?
Yes, in fact, this is what this is, which I didn't explain. LRE is the least restrictive environment. So when we talk about least restrictive, we mean most with the child's peers, and most with their non-disabled peers specifically. So there's supposed to be a preference for educating the child in the most integrated or inclusive setting as possible. So you're really only supposed to go into that special education classroom, or at the most extreme, that special education school, if there's no other way to serve this child. And right, this whole concept came about because people were like, let's stop segregating disabled kids, right? So if you have a kid that has a learning disability, they don't need to be shipped off to a different school unless they have a really extreme learning disability. They can probably just get some services in their reading class from a push-in teacher. And that's what the whole LRE concept is about. Does that answer your question?
Yeah.
Yeah. Okay. Okay. So the IEP has to include annual goals, all the related services, and the program placement. I already said all that. That's duplicative. Okay. These are the 6 principles of IDA. This one we just talked about. The other ones are pretty obvious. I like to highlight the first one. The whole thing we talk about when we talk about that meaningful benefit is FAPE. If you ever do special ed, you'll just hear people talk about FAPE, 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 FAPE. FAPE is the idea that if you have an IEP, you are entitled to a free, appropriate public education. Now you might say to yourself, isn't everyone entitled to a free, appropriate public education? No, you are not. You're just entitled to a free public education. But students with an IEP are actually entitled to an appropriate education, which doesn't sound like much, and you're right, it isn't. So a lot of parents will come to us and say, well, you know, this is what my doctor said is best for my child, or this is what I think is best. And we have to tell them, like, that's not what the legal standard is. Schools do not have to do what is best for your child. They have to do what is appropriate. So we're talking like best, we're way down here. So when we're fighting with school districts, it's about, are they doing what's appropriate? It's a pretty low bar for them to reach.
That's so difficult.
I know, but yeah, we have plenty of cases. Yeah, okay, we go to that one. Okay, true or false? A student who is eligible under an emotional disability, so their category in their IEP is emotional disability, they cannot have a math goal in their IEP. So eligibility category is emotional disability, can they have a math goal? Right, it's false. So a student, just because their category is emotional disability doesn't mean they can't have a math goal or a reading goal.
Why?
Why? Because the category does not restrict your services. Can you what?
Give me an example.
Oh, well, okay, so I may have a student who has emotional disability. He may be very behind in math and struggles, but maybe he doesn't meet the definition of having a learning disability in math. So his eligibility category is not going to include specific learning disability. Or maybe his IQ is completely average, so he's not going to meet the definition for a cognitive impairment. But he has an IEP because he has a diagnosis of PTSD and he struggles with behavior in school. If he's not doing well in math and he needs help and he needs a smaller class to get him that help, he should have a math goal. So the goals could be anywhere. You could have 10, 15 goals, or you could have one goal in the IEP. There should be a goal for every area that the student needs assistance in.
There doesn't have to be a necessary nexus between the emotional disability and
No, it doesn't
the
have
fact
to
that
be.
the child's not doing well in math.
Right, it doesn't have to be. I mean, a lot of times what we'll see, for example, is that a student is not doing well in math because they've missed so much school because of their emotional disability. They're constantly getting suspended or in the hospital. And so they end up being behind academically, even though they are actually completely capable of being on track. They need some help. And maybe when they do the annual review, they'll take that math goal out because maybe he doesn't need it anymore. Okay, true or false? A student can get weekly one-on-one time with a school social worker in her IEP. That is true. So that would be a related service. If a student has emotional needs, and this is really a better example of the first one, if you have a student who has an IEP because she has ADHD, her category is other health impairment, OHI, but maybe she also is having problems with her social skills and getting into lots of conflicts with peers, then she should have a social emotional goal, and the person who's going to implement that goal is the social worker. So that's where the related services come in. Once a student has an IEP, it follows them forever until they graduate from high school or until they turn 22. So if we have a client who had an IEP and then they dropped out and now they're 20, but they never graduated, they actually have a right to go back into school until their 22nd birthday, which is actually very helpful for some of our clients. Even if they didn't drop out, right? They have a right to be in school until their 22nd birthday or until they get a diploma. They can technically be officially exited from an IEP, but this is very rare and super suspicious. Because you're basically saying, oh, this kid is cured. Which, you know, it happens. I would say the least suspicious is when you have little kids when they're 3, 4, and they have an IEP for a speech language impairment, and they get some good services and they get past it, and they're good, they're fine. But pretty much anything else would be a very big question mark. But it technically can happen. But it's safe to say this. If, for example, you pull up an IEP and you're like, oh, well, this is from 2013, it expired, you're going to have to go through this all over again. No, 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 no. Even if the IEP wasn't updated annually, maybe because the parent, in our case, sometimes the foster parent doesn't know it exists, or the kid's moving around and it just doesn't happen, just because it's out of date doesn't mean you've lost your eligibility. It just means that the school district is out of compliance, and they should get it back together. So once you're eligible, you're eligible. Okay, so going back to this, I don't know if this makes more sense now a little bit, but 504 for students with disabilities that are impacting them in school, but they don't need specialized instruction. They just need accommodations and modifications. IEP is for students who are going to need specialized services or instruction. So they need help from a special ed teacher, a social worker, an occupational therapist, a PT, someone else. That's the very basic difference. And there can be lots of disagreements in what we do about when a kid needs an IEP or a 504. So it's not a clear-cut difference. It's a subject of a lot of dispute in some of our cases. Okay, so this is just summarizing what we kind of already talked about Section 504. I mean, Section 504, as you probably know from other areas of law, basically a 504 plan is just written accommodations modifications. There's no requirement to do an evaluation, although sometimes they do. There's no requirement to update it annually, whereas with an IEP you do have to update it annually. And there's much less kind of services you can get in there. There's also not as strong of a requirement that you have to be making as much progress. Basically, less rights. That's the basic gist.
Does the school have an obligation to spend money?
Yes. I mean, if that's what you need in order to build ramps into the school so the student who uses a wheelchair can get into the school, they have to. I mean, for 504 and ADA and 5 million other reasons, but yeah. And obviously you can see there's probably some overlap there with 504, ADA, and accessibility issues, but a 504 plan is like putting in place. Another good example of a 504 plan would be a student with a peanut allergy or any allergy, right? They don't need a special ed teacher. They don't need an occupational therapist. They don't need specialized instruction, but they need the cafeteria to be peanut-free. They need their classroom to be peanut-free or whatever it is that they need. They need to have an EpiPen in the office. Somebody needs to be trained on how to use the EpiPen. Like, that's stuff you put in a 504. Okay, so this is, some of these I already did. We already did number 1. So this is 504 guy. I just said this. That's 504. How about Steve has a learning disability and needs specialized instruction in reading? IEP, green? Right, that's an IEP, because he needs specialized instruction. Kate is diagnosed with ADHD and takes medication during school hours, and she needs extra time on tests. So she kind of needs to have a schedule for them to give her the medication, and she needs to have extra time on her tests. That can be a 504. It can be a 504 because extra time on a test could be an accommodation or a modification. You don't need to have an IEP for that. And you can have a plan for medication in place in a 504. Some school districts, you might see, they might give her an IEP just for this, but other ones they won't. But this kid probably could do just 504. But then, if you look at Kate now, same thing, ADHD, takes medication during school hours, needs extra time on tests. She also needs a smaller classroom with a special education teacher to help her learn techniques to increase focus and attention. Yeah, so that's an IEP. And the difference between these two students, I mean, they have the same diagnosis, right? But maybe this student needs more. And this student is like, I take my meds and I'm good. They don't need to be in a smaller classroom. They're fine, they just need to take their medication. And maybe the other one, even with the medication, she has a harder time focusing. It just depends on what that student needs, right? It's not driven by your label, it's driven by your individual needs. Okay, so what are the main reasons that we see cases? So we see cases a lot because a school district refuses to do a case study evaluation. A parent or a caseworker says, I think that my student needs an IEP, can you please do a case study evaluation? And the school says no. We also have times when the school district doesn't even respond to the request for a CSE, which they're required to do. They're required to respond in writing. They don't do that. I go forward. Those are really common referral sources for us. We also see, oh, you did it. Where a student, they get to the eligibility meeting and then they're found ineligible and the parent disagrees with that decision. Or we have students who have an IEP, everything's done, but they don't think the right services are in place. Okay, so let's talk about school discipline. This is, what I'm going to tell you at the beginning of this applies to every student. This has nothing to do with special education anymore. We're moving on to a totally new topic. And I have to make that clear sometimes, because we're moving on to state law. I did a Google search for school discipline cartoons and found a surprising number of cartoons, to the point where I almost started putting in like 5 extra slides, because I found it so interesting the way they were like making fun of things that I don't find very funny. Like this one, the kid's talking to principal. It says, instead of calling my mom, how would you feel about exploring more positive and preventative strategy? Like, how funny that would be. I'm like, no, that's what should be happening. I mean, this is like, this is my client, how I prep him to talk to the school. There was another one where the kid was sitting there being like, I want to talk to my lawyer. And it's like, funny? No, but that's like actually what I tell my clients to do. This one says, we're releasing low-level offenders to make room for misbehaving school kids. This is the U.S. prisons, which is also very, I don't know that they're releasing anyone, but they are arresting kids more and more for things that happen in school. So there's some truth to the funny. Yeah, okay. So school discipline. Ooh, that's one. School discipline, this is all Illinois state law now, okay? Okay, so there's two things you hear about when you talk about school discipline, and they have very different legal meanings. So I think in terms of like looking at from you guys who are not doing education law primarily, but you might be issue spotting for stuff that's going on with your clients, it's important to understand the difference between these two things. Out of school suspensions can be up to 10 consecutive school days. If a student is told to just go home from school, technically that's a suspension because they're being excluded from school. Most schools, however, don't call it that because they don't want to record it. And they're required to report their numbers to the state, and they don't look good when they have lots of suspensions. So we tell people you're entitled to a written notice of suspension, and you should always ask for that written notice of suspension. The important part to this, where we get cases, is that of the students being suspended 3 days, 3 days, 5 days, 10 days, there's probably a bigger issue going on with them that's causing that amount of behavior in school. And with our clients, there's usually an emotional disability that's behind it. So that's where a suspension is. It can be 1 day, it can be 2 days, it can be all the way up to 10 days, all at once.
And one of the other things I'll say is, while this says it's determined by Illinois law, states did not do this necessarily out of the goodness of their heart. There's a case called Ross versus Lopez,
Yep.
Which is a U.S. Supreme Court case in the 70s that kind of eventually led to these kinds of laws being enforced.
Sure. There is case law that is from the different states that will impacts, especially we'll talk about expulsions. And there's data reporting requirements. Like when I talk about suspensions, school districts have to report that to the Department of Education, and that's one of the reasons they don't like documenting suspensions, because they get in trouble, theoretically, not really, for having high rates of suspension. Okay. So a suspension of 10 or more days is technically an expulsion. So you can't be suspended for 11 days or 12 days or 30 days. That's an expulsion. And when you move up to an expulsion, the student's due process rights increase, okay? So once you go up to an expulsion, first of all, under Illinois law, a student can be expelled from school for up to 2 years. They just passed a law saying that you can't expel pre-K kids. There is no such law for kindergartners or first graders or second graders or anyone like that. So under this, if a student is expelled, they are expelled they can be up to 2 years. And that doesn't mean they can go to the next school district. It applies to every school district. So if CPS expels you, you can't just pick up and move to the suburbs, besides not having the resources to do that. And I think a lot of parents don't understand that. And that's why I kind of tell people, if you're practicing another area of law, and your client remarks like, oh, we have an expulsion hearing, like alarm bells should go off in your head, because I would always want a kid to have an attorney at an expulsion hearing, because it has serious consequences that parents don't normally understand. They think, well, I'll just take them to the next school, or we'll just move, or maybe this will just be another week. And it's like, no, it could be bad. Some school districts will pay for the student to go to an alternative school while they're expelled, but they do not have to. So it's a big deal. So when you are having an expulsion, because of case law and Illinois state law, you're entitled to a little bit more due process, which means the student is entitled to a hearing. The kind of standards for the hearing are pretty low. The parent's entitled to notice, but notice could be like the day before. They're entitled to give their side of what happened, so the kid's entitled to speak. You're allowed to bring an attorney if you want, although obviously you don't have a right to an attorney. You have to pay them out of your own pocket or find someone like LAF who will do it. And you're allowed to kind of ask questions of the other side. But that's about it. So it's pretty brutal. Normally it's a hearing officer. It's like a very casual trial, usually done at a conference room in the school. And there's usually a hearing officer who then makes a recommendation to the school board. Sometimes, in certain occasions, they will just do the hearing in front of the whole school board. It depends on the district and how big they are and how many kids they expel. So we always try to represent students when they have an expulsion hearing, because it's a pretty big deal. Okay, so true or false? Anne has been getting in trouble in school, and the principal keeps calling her parent to pick Anne up because she's having a bad day. The parent should ask the school to provide a written suspension notice, true or false? Yeah, and I would say true. A lot of parents, I think, get the call and it goes, Anne's having a bad day, I'm not gonna suspend her, just come pick her up. And the parent thinks, good, I don't want my kid to be suspended. But the problem is that when it happens every week and the school isn't writing it up, there's no documentation. So parents come to us all the time and they're like, they're sending home my 4th grader like once a week, twice a week, every single week. And I think we need to see whether he needs an IEP. I think we need to see what's going on in school. And then we go to the school and they say, we don't know what you're talking about. We haven't suspended him once. So sometimes we have to talk to parents about the fact that it actually might be a good thing for them to be recording this, because it does show that they're pushing out the student instead of dealing with what's really happening in the school. Okay. So let's go back now. Now we're talking about where special education and school discipline intersect. So the basic gist to this is that it's important to know that students who have IEPs have more rights in terms of discipline process than students who don't have IEPs. That's the gist. In fact, I could probably just end it there. For you guys who don't need to know the details of this, the gist of this is that if a student is suspended for more than 10 days total in the school year, there has to be a meeting of the IEP team to discuss whether the suspensions are related to their disability. So if the student got suspended for 10 days because they brought a knife to school and their disability is, what would be a very, that they have a reading learning disability, probably not going to be found to be related. But if the student has PTSD, I always use this example, and a security guard grabbed them by their name tag around the neck and said, where are you going? You're here in the middle of the hallway, which happens. And the kid kind of freaks out and pushes the security guard off of him because he's not comfortable with that. I don't know who is, but that arguably would be, that behavioral incident would arguably be related to his disability. And the gist behind this whole thing is you shouldn't be suspending and expelling kids for things that are related to their disability. It seems like a pretty obvious concept, but that's the whole idea behind these extra protections. You shouldn't be expelling a kid because they're doing something that's related to their disability. Okay. Let's go to the next one. Okay, so now we're going to talk about these 3 sections real quick. Uh-huh.
Do you have, does parent have any rights regarding suspensions?
They have a right to written notice.
Beyond that, I mean,
So
suspending my
according to
child.
the case law that Rich talked about, Goss v. Lopez, which is a Supreme Court case, it basically says for any exclusion from school, you're entitled to due process. The level of due process is like a spectrum. So if you're suspended for 1 day, you're entitled to less due process than if they're trying to expel you for 2 years, which is why expulsion hearings are a little more formal. But they do have to have an appeal process for suspensions. We honestly don't do a lot of that because by the time we get in and appeal it, the suspension's over. So I think you see that more where people are concerned about the record and what the kid's record is going to look like for college, and they want it taken off the records. By the time you appeal a suspension, it's normally done.
In Chicago, Loyola has a special project.
Yes.
Works on
In fact,
suspensions.
Chicago, Loyola Law students have a special project that they started just for this reason because not a lot of legal aid people will do suspension appeals. It's called SUFEO. They have a hotline, and they basically tell people what their rights are for appealing suspensions. And they've had some good success with it. Okay, so talking about school records, there's 2 main laws, one federal, one state. Federal, FERPA, you probably have all heard of FERPA because it regulates everything in education records. The gist behind FERPA is that your educational records are private. Although what we like to point out with FERPA and the way we use it and the way that you might use it is that under FERPA, parents or students themselves are entitled to inspect or review all their records within a reasonable amount of time, which they say is about 45 days. That can be very useful, and I'll explain in a second. If we go to ISRA, this is the Illinois law, which is actually better than FERPA in terms of this record production, because under this you have 15 school days. So this is I think, an underused resource in other areas of law, and something I wish I had known about when I was doing family law, or really if you're doing public benefits, family law, anything. It means that you can basically send a letter, and we have sample letters, to a school district with a signed consent from the parent, saying, I want all of this student's records. And they have to send them to you in 15 days. In some circumstances, they try and charge us, although I haven't done that lately. But this is, I think, would be incredibly useful discovery. If you're trying to prove that your client is the one that goes to all the meetings, find the records. If you're trying to prove that your client has services in school and what services in school and this is why they should get SSI, get the education records, because parents don't always have this stuff. If you want to show that they struggle in school and they have a disability and the teachers all note it, ask for the records. The teacher should be keeping notes. So it can be incredibly useful, I think, in some areas of law. If you're trying to show where they were living, who was going to the meetings, what kinds of services the kid is getting in school. If your kid is reporting to the school that they're really anxious about seeing a parent, or if whatever's going on, it should be in the school records. Obviously confidential kind of therapy notes wouldn't be in there. Social workers probably aren't keeping notes and turning them over. But in general, I think there's a lot of stuff in there that people don't think about in terms of when they're doing kind of non-traditional discovery in cases. And all you have to do is send a letter. So if you ever want to do that, ask one of us and we'll give you a sample letter. Okay, school residency. I think it's really important to understand this as well and when you're practicing other areas of law. So school residency, this is Illinois law now. We're talking about school districts, right? Within a school district, each school has an attendance area that says if you live on this block, you go to Lincoln Elementary. If you live on this block, you go to Smith Elementary. When we talk about residency, we're really talking about what school district do you live in, okay? This is all very easy if you live in Chicago, because everyone in Chicago goes to CPS. It's a gigantic school district. But where it really gets touchy, and where I don't think people realize, is in the suburbs. Suburbs are not cool with kids who don't live in their district going to their schools, because that is money. They do not want kids who don't live there, and they spend a lot of money. They hire private investigators, who sit outside of people's houses and videotape them, record them, all to prove that they don't live in the place they say they live. So they take it very seriously. So I think it's important for you to realize, I think especially when you're dealing with family law cases, the dynamics of this. Basically in Illinois, the student should go to the school district that is the residence of the person with legal custody. And this is not the same definition as it is in family law, in the IMDMA, right? This is the definition. It can be a parent with whom they reside, court ordered or not. It can be someone who's their guardian, either short or long term, but they have to actually live there. It can be an adult caretaker relative who basically doesn't have official guardianship, but who they actually live with them and they take care of them. Or another adult who's assumed legal responsibility. The important thing here is that they have to actually live there. And it must be their regular fixed nighttime abode, meaning the majority of the time. It doesn't have to be 24/7, but you need to be able to show that's actually where they live the majority of the time. Or else that school district is gonna possibly go after them. Court order custody is not required. So school districts are not allowed to say to a parent, I need to see your custody order. They're not allowed to say that, because as we all know, a lot of people don't have custody orders. They just have their kids. But it can be helpful if you're trying to enroll a kid in school. And a kid cannot be living with someone just to gain access to the district schools. Now, this is always, I think, a really interesting provision, because how many people buy houses in Winnetka so their kids can go to New Trier? Like, all of them, probably? So they're all living there for that purpose, more or less. But what this really means is that you can't go live with your aunt because your aunt lives in New Trier's area. You have to actually be living there. And how do you draw the line on that? Would be up for interpretation if it went to court. Okay. So the important thing about school residency, there's no time requirement, right? If you move into an apartment tomorrow, you can go enroll in school the next day. They can't say, oh, you have to be here a month or something. It's also important to know that under Illinois law, if the student starts the school year in District A and then moves, like in October, to another school district, they are entitled to stay at the other school for that school year. And that's pretty important, I think, especially for clients who are fleeing domestic violence or who are moving for whatever reason. They are entitled to stay at that school. However, they will not receive transportation. So sometimes it's not really practical. Even if they have the right to stay, the parent can't get them there every day, so they don't. But they can, and it's important to know that's a right. This is really important, another big, issue spotting thing that you should all be aware of. If anyone you're ever is a client talks about getting something in the mail that says the school district, it would be sent certified mail, says that they don't live there, and that sometimes they should technically say on there, you owe us $10,000 in tuition, or whatever the tuition is. And it will be thousands and thousands of dollars, depending on how long they think you've been lying. Parents, this is really important, they have to request a hearing within 10 days of that. And if they don't, they're literally liable for whatever money amount they put in that letter. So it's insanely important that if anybody says they got a letter from the school saying we don't think you actually live here, that they respond within 10 days and ask for a hearing. And then if it comes to that, we have a residency hearing. Just like an administrative hearing where we try to prove they live there and they try to prove they don't, and they bring in their private detective who testifies about following the family around for days. It's very weird. But it has serious financial impacts on clients. It's also important to know about McKinney-Vento, which is the law that was created for homeless students. This is a federal law that basically gives them extra protection. Homeless students would apply to anyone in a shelter, including domestic violence shelters. It would also apply to students, obviously, who are living in cars or motels or any other non-building type residence, storage units. It also applies to families that are doubled up. So if mom and kids leaves the home of abusive husband, goes to maybe her sister's house where her sister lives with her husband and her kids, they're doubled up. Mom and her kids are now technically homeless under this law. So they have a right to keep going to their school of origin, and they have a right to transportation. And that is the big thing about McKinney-Vento. That if you're homeless, in order to try and keep you stable in terms of school, the school district has to provide you a bus back to your old school. And that is a huge advantage for some families. That otherwise there'd be no way that would work. But it's where this, which is every kid, and this is kids who are homeless, have this kind of extra help.
Ever representing a homeless kid in college action? Or ever a family that's homeless and you have questions
Yeah.
about education, call somebody in the education guide.
Yep, because they have lots of additional rights, which are important to know about, including, there's a lot of stuff I didn't put in there, but like speedy enrollment, they don't have to have the same documents. Like, a school can't say, I need your birth certificate. Mom's like, I'm living in a DV shelter. McKinney-Vento says they have to enroll them without the birth certificate. So it's actually very useful for people in DV situations. Okay, Title IX cases, we've had a couple of these over the past couple of years, which we really didn't do before, but now with Micah in class, we're doing more and more of them. The basic gist of Title IX, and this is obviously in flux, all this guidance was just rescinded recently, but from what I've been able to scan through, this stuff is still in place. But it's definitely, the scene of it is changing. Everyone thinks about Title IX as being a college thing. It applies to K-12 too. So if you have gender-based harassment, which would obviously include sexual misconduct, sexual assault, and it's, there has to be some nexus to the school, right? In most of our cases, it's student on student, doesn't have to be at school, but if it's between two students at the school. There has to be a school district policy on Title IX. They have to have a Title IX coordinator. They have to do an investigation. Sometimes this is a good thing, sometimes it's a bad thing, because sometimes they don't do great investigations. This is changing a little bit, but basically either party can receive interim measures, which can be things like changing their class schedule so they're not together, changing their lunch so they're not together, giving one student social work services in the meantime, whatever it needs to be. It's kind of broad interpretation, but it does mean that you have rights to ask the school for some help. And then there's an adjudication of responsibility that can have a hearing or not have a hearing. But it basically is what you think of when you think of Title IX, but for K-12 kids. So it can be a great resource or a very, or not, depending on the school district and depending on the situation. Okay, true or false? Our client's marital settlement agreement states that the parents have joint decision-making in education matters for the child, Robert. Robert lives with our client, mom, 80% of the time. Dad moved into a district that everyone agrees has better schools. If mom and dad agree, the parents can send, as long as mom and dad agree, the parents can send Robert to either the school district where mom lives or where dad lives, true or false? Can they send him to either school district, true or false? Right, it's false. They cannot send him to dad's school district. And this is something I tell people, because I think sometimes, and I will say this, as doing family law for a long time, I 100%, if this had come up, would have written in there, kid is gonna go to school in dad's school district, thinking that that was good enough. It's not. School districts don't care what your MSAs say. They do not care. They're not gonna pay $40,000 to educate that kid if they don't have to. So don't think that just because you put it in there, that somehow it can be ignored by the school district. It won't.
So that means that they have to be, like, the father has to have full custody, or like
It's,
what would
well, so in Illinois, it changed, right, to basically parenting time and joint decision-making. What matters is where is the kid's regular fixed nighttime abode. So where that's gonna translate is where do they spend the majority of their time. So I would say if they're 60% with mom, they have to go to mom's school district. Yeah.
Well, I think in Chicago, in different attendance districts, this doesn't really come up though.
Doesn't really come up. There are lots of kids who go to schools that are outside their attendance area in Chicago, and it doesn't, there's no risk of tuition or anything like that. Sometimes there's risk that schools will be like, no more, and kick you out. But that, it's also really complicated by what type of school we're talking about. So if you have that come up, just ask someone on the education law team, because CPS has so many different schools, and they all have different types of rules. So it's important to know where the rules are. But you're not gonna get charged tuition if you live in North Lawndale and you're going to a school that's in Lincoln Park.
Okay, so we're gonna zoom through some child welfare stuff. And child welfare encompasses a lot of stuff. When I go out and do introductions about myself or other agencies, I always say I work with Dcfs impacted families because it's just the best way to describe it. But just to give you a sense of what that means, that could be an administrative hearing where we're talking about doing an indicated report appeal. It can be a foster child removal hearing. It can be a licensing issue, a licensing hearing. It can be an administrative review action in chancery court. It could be juvenile court representing a parent. It could be juvenile court doing foster parent advocacy. It can be a probate court petition. Either I do non-parent representation in probate courts. It can be related to a domestic relations case, and it can also deal with post-adoption, post-guardianship issues with Dcfs. So all of that is encompassed when we talk about child welfare. So that's a lot, and the attention we pay to various areas is kind of ebb and flow depending upon what's hot, what we have resources for. But those are all questions that Rich and I are we can try and answer them for you if something comes up a little bit unusual. So like, they say they have this money, I don't understand what this means. Or they say they're having this issue and they're dealing with this person at Dcfs, what does this mean? We can try and suss that out for you. But I'm going to focus on Dcfs investigations. Now, when clients call, they just sort of lump everything in as Dcfs. And the most typical response is, CSU gets a phone, Dcfs took my kids. Well, that's by no means the end of the inquiry, because Dcfs took my kids might mean there's a juvenile court case. It might mean there's been Dcfs involvement and now it's a domestic relations case. It might mean that there's a probate guardianship case. It might mean that there is a adoption petition or termination of parental rights pending. Or it could be safety planning. Or it could be foster child removal. So Dcfs took my kids encompasses all of those things. But we're going to focus on indicated report appeals. All right?
Can I do this in the right order? Or am I doing
So people come to my office all the time, they say, oh, I have a quick question for you. And I always say, pull up a chair because I have no quick answers. You come in my office with the Dcfs case, you'll be there for a while. But I want to say the Dcfs rules is really important because, again, clients always say, oh, Dcfs caseworker, but there's many roles, but these are the two most important roles. These are the two types of workers that clients will encounter. The DCP investigator and the Dcfs caseworker. And they're not supposed to do the same job. They're not supposed to overlap. They have two separate roles. So the DCP investigator is the person who actually does the Dcfs investigation and makes a determination about whether or not your client's going to be indicated for abuse or neglect. So they say, was the child abused or neglected, and is the child safe? And they do safety determinations. The Dcfs caseworker is the person who starts working with the family and says, okay, I'm going to try and find you appropriate services, and we're going to talk about what your family needs in order to function more effectively. They can be provided in foster care settings or intact services, and the DCFS worker will work with will testify in court regarding how the case is progressing down in foster care and make recommendations to the court judge. And this is the other important thing, is that DCFS has contracts with private agencies. So sometimes the caseworker is not going to be a DCFS employee, it's going to be a private agency worker. And again, the clients always say, my DCFS worker, and then you find out it's actually somebody from Association House. Well, it probably means that they're just a private agency worker that has a contract to do work with DCFS. Okay. Okay, so here's the investigation process. There's always, if you had asked me 6 months ago, I would have said the DCFS investigation process is functioning pretty well. It does seem like it's sort of fallen apart recently. I have my suspicions as to why, but the truth is that there's a lot more problems than there used to be. But from a client's perspective, the investigation starts under the hotline called DCFS. We have mandated reporters, which are basically professionals that have reason to believe that the child's abused or neglected in the course of their professional conduct. And they are not required to make any sort of baseline determination as to, there's not a threshold. If they feel that there's something that needs to be figured out, they call DCFS. And then DCFS will accept phone calls from private individuals who are not required to call, but they may call. We do know that a lot of times phone calls get screened out because it's perceived as just a domestic dispute between various family members, or it's just somebody trying to take advantage of the DCFS process to gain an advantage in a domestic relations case. It's not supposed to happen, but we know that it happens. So there are very important timelines. The DCFS Investigations is governed by DCFS Rule 300. They're supposed to see the child victim within 24 hours. They're supposed to interview or attempt to interview the alleged perpetrators within 7 days. They're supposed to complete the investigation within 60 days. They can ask for one-time extension to 90 days. And the outcome of the investigation is going to be indicated or unfounded. Unfounded means we have found no credible evidence of abuse or neglect, client doesn't need to do anything, it's over. Indicated means we've determined that a person has perpetrated abuse or neglect. The parents, the alleged perpetrator is entitled to written notice of the outcome. This is a really nice timeline here, 60 days, that's a long time. So you have 60 days to file your appeal of the indicated report. Now, in the investigation, there are certain points in which the DCP investigator must make the safety determination, but they can also make the safety determination anytime that seems appropriate to them. They find a new piece of information, they don't have to wait until, they can do a new safety determination right that day. But they're supposed to do it at initial contact and at various other points, including case closure, that they do the recommendation. At the same, okay, one. So we keep talking about the allegation system. The important thing to know is that there's a definition of abused child, neglected child, also dependent child, in the Abused and Neglected Child Reporting Act. And then there's a much more, there's a DCFS is what they call their expanded allegation system in Appendix B. And so they kind of break it down into more, many categories. And so we always ask, so do you know what number they were indicated for? Because what we're trying to figure out is where they fall into the indicated report system. If the number's under 30, it's an abuse and actually done by a trained forensic interviewer. So there's a really nice protocol. These can sometimes be very helpful, but they're very hard to get a hold of. So if you're ever in a situation where there's a BSI issue, that's where you need to talk about, oh, is that something I can actually get access to if you think it's relevant to a case that you're handling. Another piece of information is, oftentimes there is a criminal investigation going on at the same time as the DCFS investigation. And We take a very cautious posture. We always advise people, oh, you need to consult a criminal lawyer. Because any admissions that are made to DCFS can be passed on to the police. And there's no Miranda warnings, there's no information given to the client about the potential consequences. So again, if anybody ever says they have a DCFS investigation, and there's any reason to believe there's criminal investigations, that person needs to consult with a criminal lawyer. Okay. So, what does it mean to be, for the DCFS indicator reports? I mean, what's the significance for our clients? The good news is that these are confidential. If you are indicated by DCFS, you are put onto what's called the State Central Register, which is a DCFS database regarding people who've been indicated for abuse or neglect. It's confidential. A lot of times people get worried because they're told that they're going to be on this list and they're afraid about background checks. But a client who is applying for just a general job and the standard procedure to do a background check, even a criminal background check, or you're applying for an apartment, this information is not going to come up. But there are some exceptions in which it will come up, and it's very important. The most important being, if you're going to be working with children, and sometimes some other populations, as a condition of employment, you are required to submit to a CANS background check, and that's where it will come up. So because this background check can cause you to lose employment or not be eligible for employment, there are it's really important that clients be aware of what the implications are of being indicated, and encouraged to file an appeal. And of course, another exception to confidentiality is juvenile court cases. As soon as you're in juvenile court, DCFS files get passed around like candy. Everybody gets it. I mean, juvenile court is still confidential, but now if you have other family members who are involved in a juvenile court case, they'll have access to your file. And then there's a provision for in-camera review of DCFS files by a judge. So this can be used by a domestic relations judge or probate judge, where they can actually say, oh, there's DCFS involvement, I'm going to order the files, I'm going to look at them, and I'm going to decide whether or not they're going to be made available to the guardian ad litem or to the parties in the case. So when people are indicated by DCFS, this is the other important thing, is the retention schedules, because you're not on the DCFS SCR for the rest of your life. There's a set period of time, and 5 years is the standard to be on the State Central Register. Some things are held for longer, 20 years and then 50 years. 50 years are for the most serious allegations, but most of the cases are going to be for 5 years, although I did have somebody who had a 50-year retention once, because she got indicated for death by neglect. We won. So, who can be indicated? It was a sad story. So, who can be indicated? Not everybody who abuses a child is going to be indicated by DCFS. You have to be in the position of being a responsible person to be indicated for DCFS, which means that when the next door neighbor who is not the responsible person actually abuses your child, they might be criminally prosecuted, but they're not going to be indicated, because you didn't put them into that person's care. They just took advantage of it. So but that's why a teacher can be indicated, because they're responsible for the child's well-being in the school setting. So even though they're not related. So responsible person can be indicated. So that's another thing. Sometimes people think, oh, my boyfriend can't be indicated. Maybe he can. So notice of outcomes. This is something what DCFS always screws up. Oh, I've got 3 minutes. This is something DCFS always screws up. They're pretty good about giving notice to the alleged perpetrator, but the other parent is also entitled to notice. DCFS is not sometimes good about that, but a lot of times they don't give the outcome to the parents. Here's another interesting thing. If you're interviewed by DCFS as a witness, you're entitled to know what the outcome is, whether or not the child's been indicated. The whole idea being, well, now DCFS has put your grandma on notice that they have a concern about the care being received in the person's home, maybe grandma should know whether or not there's actually a serious problem. So I've been able to use that to my advantage. Okay, so the decision to indicate is made by the DCV worker in consultation with their supervisor. The standard is very low, some credible evidence, extremely low standard. They take the position of like, if you didn't do it, you'll care enough to file an indicated report, or to file an appeal. So then, if you file the appeal, you go to the appeal process, and you have your evidentiary hearing with the administrative law judge, who's a lawyer. You have the right to bring a lawyer. It's recorded. You have the right to cross-examine. You have the right to production of documents. The right to examine all the materials ahead of time. The burden's on DCFS, which is really nice, and then it's the preponderance of the evidence standard. So we win a lot of cases where the DCPA worker did a very good job of the investigation, but we went to the hearing and we prevailed because it's a different standard of proof. So we don't have to prove that they did not do their job at the investigation. So for issue spotting, this is so quick, but essentially people call and say, I have a DCFS case, and that doesn't tell me anything. So the big difference is sort of like, well, are you actually going to court, and what court are you going to? Or are you, did you just get a letter in the mail saying that you were indicated and you have pre-hearing telephone conferences? That allows me to determine whether it's a juvenile court case or whether they're just doing an indicated report appeal. And if you ever have any questions, don't hesitate to call me, because it's usually pretty easy for me to figure it out with just a couple clues from the client. Appeals process, we do indicated report appeals. They're fun. So again, always do a consultation about whether or not it's a good case for us to get involved in. When they do the outcome of the hearing, they get a written decision. It's supposed to be sent certified mail. The timeline is 35 days. This is an administrative hearing decision, and the Administrative Review Act applies, which means you have to file the appeal within 35 days. It's not the same as administrative decision subject to a writ of cert. Very important. Clients blow this deadline all the time, unfortunately. So, we're gonna stop here. But
Yeah.
like I said, if you want to spend an afternoon chatting about DCFS, come to my office.
And, and we will try to do a longer one. This is just to kind of give everybody an introduction to these issues. So what Colleen has talked about is kind of the Dcfs investigation process, indicated reports, and this administrative appeal system for appealing those. I'm going to just, I have about 4 slides, which I'll get through really fast. Do you want to hit the space bar, Ashley? Okay, one more.
Skip that.
So DCFS, when they do that investigation, can decide, do we want to take the kids away or do we want to leave them in the home? If they take the kids away, unless the parents agree to it, say, I'm going to let my sister become the guardian of these kids, that case will end up in juvenile court. In some states, cases come into court whether or not the agency wants to take them out or not. They want to just monitor services in the home. Theoretically, in Illinois, that can happen, but in Cook County, that almost never happens, that a case goes into juvenile court just so they can monitor the family. Okay? When the case goes into juvenile court, it's because it's not in the state's economic interests to have large numbers of kids in foster care. There's a heavy screening process. So if the case makes it into court, there is about a 99 to a 99.5% chance that the issue of whether the child was abused or neglected is not really going to be a legal issue in court. It may well be an issue, but it's 99 to 99.5% of the cases they find that the child was abused or neglected. And really quickly, what happens is it starts off with a temporary custody hearing where you have to have probable cause of neglect. Really low standard, but you also have to show that there's serious risk to the child, and the court is also supposed to find that DCFS did something, made reasonable efforts to keep the kid out. Adjudication happens about 3 to 9 months after that. Meanwhile, the kid is in the temporary guardianship of DCFS and is in a foster home with a relative or a non-relative. So if a client ever says, I'm a guardian of my niece, you should say, now is the case in court? If they say yes, it's over by the Audi home, or if it's over on Hamilton Street, or it's in juvenile court, that means it's in juvenile court and they are foster parents or the equivalent of foster parents, which means they have a whole different set of rights and they are not actually the legal guardian. So if that issue pops up, it pops up sometimes in housing cases, sometimes it pops up in immigration cases.
Education cases?
Education cases. You should ask them that, and if you have any questions about whether that has any impact on your case, let us know. The adjudication looks back and says, when this case came in 3 or 9 months ago, was this an abused child and was a parent responsible for that? Okay? Once the court finds that, it's the weirdest kind of case ever, because you literally can make the evidence. So they've taken the case of the child away. They said, yes, the court has jurisdiction because you're abused or neglected. But now the question is about, is it going to become in the best interests of the child to go back home, and are the parents now fit, willing, and able? And there are other clients that we have who have gotten their kids back. We used to have a much bigger practice in the area. Our office had a number of individual grants. We were able to do more cases. We're much smaller on that now. But we established the burden of proof in termination of parental rights cases in Illinois. Got kids back home. Colleen has a couple of families who were reunited through her work in cases that involve domestic violence. So it's a case where literally the evidence gets made as the case is going along. And when it comes to the point where you think your client is able to step up to unsupervised visits, step up to getting their kids back, you file motions to do that. So there's a lot of litigation involved, a lot of discovery. If it doesn't go that way, it goes to termination of parental rights. And termination of parental rights is the death penalty for parental rights, which means they're terminated, you have no right to see your child, you have no right to visitation with your child. Illinois is not a state that has open adoptions by law. There's open adoptions if the adoptive parent lets you see the child, but Illinois does not have open adoptions. You can adopt the child, but you have visitation. We have juvenile court cases can also end in guardianship, which is kind of like it's kind of like termination light in some ways, but the parents retain the right to try to get their child back if they make some recovery. But if I was the parent and Colleen was my sister, and they say, okay, because you're not ready to get this child back, and your spouse is not ready to get this child back, and so the child is going to stay with Colleen in guardianship, and we will continue her foster care payments, but we'll close the juvenile court case and Colleen will remain the guardian. Eventually, if I miraculously come back and I get, from whoever the current TV expert on parenting is, says, Cazola's a great parent now, I could theoretically file then a motion to get my child back in the juvenile court. So the take home on this, because there's not time to kind of go into all this, is in your work. If somebody comes to you and says, DCFS is investigating, I don't know what to do, there's Colleen, there's me, Steve Pick, who's in public benefits, knows a great deal about it because he's done child welfare work for about 8 years. There are other people here in this room, Steve, who knows Indiana law on it, Caitlin, and a couple other people, and Callie, who are in Loyola's child law program, who through the clinic there have some knowledge of Illinois laws on it. But always feel free to ask us for help in those areas, because the main thing is to ask us questions.